And what Ms. Oniki testified to was that there were 24 people reviewing signatures. Now, in her declaration, it's unclear whether they were all level 1 or it included level 2 and 3. But what she did say is that at level 2, there were at most 3 managers. And those managers, after the level 1 signature reviewers looked at the signatures, would then take the rejected signatures and do a subsequent review. But again, there were only 3. The rejection rate that she testified to was that 30 to 40% were being rejected by the level 1 reviewers. Yvonne Nystrom testified similarly. She testified at her location there were 2 managers at level 2. Again, rejection rates of 35 to 40%. Mr. Myers, where the bulk of his job was involving ballot curing, so when a rejected ballot comes back, it goes through a curing process to determine whether or not the voter is actually who they say they are. And if that curing process does not result in a confirmation that it is that voter, that ballot is illegal and should not be counted. This is what Mr. Myers testified to as part of the curing process. Talked about the room where they were in. He was always told that they were going to be in for hell because they were processing about 60,000 ballots a day. Again, there's 1.3 million ballots. They were rejecting about 12 to 15,000. This is every day. And it would go up to level 2, and he was told that your next day is going to be hell. But when it came to the next day, only about, at most, 1/10 of those ballots came to him. So let's look at the math, Your Honor. 12 to 15,000 ballots a day are being sent up to level 2 because they've been rejected. 10% come back. That means about even taking the lower number of 12,800, or 12,000, 10,800 ballots were approved by the level 2 managers. You have at most 3 level 2 managers. That equates to 3,600 ballots per manager to review in a day. These level 2 managers, by the testimony, have additional signatures on file to see if they can find a match. They have tools that they can zoom in and everything else. If you assume they spent just 1 minute reviewing each signature or each ballot envelope to compare, that would be 3,600 minutes. Well, that equates to 60 hours. Well, a day only has 24 hours. So what does that mean? Well, if it's 24 hours, that's about 25 seconds. And as Mr. Myers testified to, and these are his exact words, the math does not add up. Tens of thousands of ballots were being pushed into the system that should never have been counted. That is shown by the examples that we gave, Your Honor. And what is compelling, even more so about that testimony, where we put forward 5,384 or 387 ballots, I believe. Those were 2020 ballots with names that voted in 2022. And that's an extrapolation based on the sample, a random sample that came from, that would mean when you're counting 1.3 million ballots, that number extrapolates to about 130,000 total. So again, these are outcome determinative numbers. The defendants say that we haven't introduced thousands or hundreds of declarations from people who said they were disenfranchised and didn't cast a vote. But if we had done that, Your Honor, then the defendants would have said, well, how do you know? And it's actually precisely that situation that the Supreme Court of Arizona raised in Huggins, is that type of testimony is inherently unreliable. But what we do, again, offer is substantial expert testimony based in science that between 15 and 29,000 voters were disenfranchised. In terms of the chain of custody, we put forward sworn testimony from a poll observer at MTech who observed all of the trucks coming in on election night where there were no chain of custody seals, no chain of custody forms with all these ballots. Her testimony is also corroborated by a whistleblower at Runbeck who testified that she overheard a call from MTech asking Runbeck what the count was. Now, MTech is supposed to know that count because under Arizona Code 16621E, maintaining proper chain of custody means you know what the count of the ballots is. The other thing that the Runbeck whistleblower testified about is that Runbeck, which is not an authorized drop-off facility, allows its employees to cast their ballot there. Now, she did say it was only 50. She's very upfront about that. But the point is, there is no way to tell. And we've already shown that there is an unexplained, somehow they found 25,000 extra votes between November 9th and November 10th. And again, that's outcome determinative. So it's not merely speculation about a chain of custody violation. There's actual numbers there. And it could be far more than that. But their own numbers don't reconcile. And that's the point. And they don't reconcile in an amount that is outcome determinative. In terms of the constitutional claims, Your Honor, that were brought in this action, because this is a special action complaint and an election contest, there's nothing in the statute that prohibits those claims from being brought. The one case that the defendants cite, O'Donoghue, regarding the court rejecting a mandamus petition. Under a mandamus position, the law says you cannot have any other relief. So mandamus is your only option. A court ruled that a special action was an alternative form of relief.